I'm Lisa Girdwood from the Brodies Family Law team, and we have a wonderful panel of speakers today addressing the matter of adoption and post-adoption contact. Now, I think we all know there have been many changes in the adoption process in recent decades, as well as a growth in our understanding of its impact, both positive and negative, on the children who are at its heart. The importance of family, of a stable and loving family, to the well-being of a child cannot be underestimated. Children may have experienced traumatic reception into the care system, then separation from birth parents and siblings, and then further separation from foster families as they move to adoptive homes. The impacts of these events can be lifelong. Our speakers today are going to explore the adoption process itself, recent case law in the field, and from a psychological perspective, the importance for children of maintaining contact with their birth families. Now, there is a brief agenda which will appear on our screen shortly, and that just takes you through what we're going to be addressing today once again. And now I'd like to introduce you to my colleagues, Donna McKay and Fiona McLeod, who are going to discuss with us the process of permanence orders and the intricacies of adoption. Thank you.
Thank you, Lisa. Good morning, everybody. My name is Fiona McLeod. I am a legal director and solicitor advocate, and I sit within Brodies' public law team with a particular specialism working with local authorities in respect of children and family services. And I'm joined today by my colleague, Donna McKay, who's a legal director who sits within our family team. And Donna is going to talk about, after a permanence order, perhaps with authority to adopt is granted, the adoption process and the work that our family law team can do with the prospective adopters in terms of securing that adoption. So just if we just move on to the next slide, and I'll just chat very briefly about what I'm going to speak about this morning. So I'm going to talk about permanence orders. I'm going to talk about what the subject of the orders are, what's the threshold test, what are the subsequent tests and the additional tests for authority to adopt, and the court process. So permanence orders were established under Part 2 of the Adoption and Children Scotland Act 2007. They're orders made on the application of the local authority, and it vests in the local authority the rights to regulate a child's residence and the responsibility to provide guidance to the child. Permanence orders regulate the exercise of parental rights and responsibilities in respect of children who cannot reside with their parents, but where contact or shared exercise of parental rights and responsibilities may be appropriate. Permanence orders can also remove some or all parental rights and responsibilities and grant them to other persons specified in the order, and that can be either the local authority or perhaps where in cases where it's going to be a long-term foster placement with the foster carer. So what is the subject of the orders? The legislation governing the making of permanence order is contained within sections 80 to 84 of the 2007 Act. So if we just come on to the next slide, please. And section 80 provides that the court, on the application of a local authority, may make a permanence order in respect of the child. And that permanence order is an order consisting of the mandatory provisions, ancillary provisions as the court thinks fit, and if the conditions in terms of section 83 of the Act are met, provision granting authority for the child to be adopted. The mandatory provision is set out in section 81 of the 2007 Act, and we've set that out on the slides here. So it's a provision vesting in the local authority the responsibility to provide guidance appropriate to the child's stage of development, in terms of Section 1 of the Children's Scotland Act 1995, and the right in terms of Section 2 of the 1995 Act to regulate the child's residence. The mandatory vesting of this right in the local authority reflects the notion that the child cannot return to live with their birth parents. I don't want to cut across what others may talk about this morning, but I do want to note here that there was a recent Sheriff Appeal Court case, Glasgow City Council against MM, in relation to whether permanence orders have to have both of these mandatory provisions, or if it's an or situation. And what the Sheriff Appeal Court held was that permanence order would not be competent unless both of those mandatory provisions that are set out in the slide are contained within the permanence order. In addition to the mandatory part of the permanence order, the court may add such ancillary provisions as it thinks fit, and that's in terms of Section 82 of the 2007 Act. And that allows the court to redistribute the parental responsibilities and rights from the 1995 Act. Certain parental rights and responsibilities are vested in local authority under Section 82, and these are that the parent has a responsibility in respect of the child to safeguard and promote the child's health, development and welfare, and to provide an appropriate development of the child and direction, and also to act as the child's legal representative. The court can also vest in the local authority the right under Section 2(1)(b) of the 1995 Act to control, direct or guide in a manner that is appropriate to the child's stage of development, the child's upbringing, and the right under Section 2(d) to act as their legal representative. The court is unable to transfer parental responsibility under Section 1(c) and the right under Section 2(c) of the 1995 Act, that if the child is not living with the parent, to maintain personal relations and direct contact with the child on a regular basis. Both of these provisions can't be subject of permanence orders, and instead they would be dealt with by contact orders in terms of Section 11 of the 1995 Act. And if the local authority is looking to apply for a permanence order with authority to adopt, then there are additional conditions that must be met to ensure such an application is competent. And I will come on to talk about those additional tests for permanence orders with authority to adopt very shortly. And just mentioned at the end of this slide, in cases with permanence orders, the parental rights and responsibilities are transferred and they're not extinguished in respect of permanence orders. And I think Donna will probably come on to talk a wee bit more about that when she talks about adoption. So just moving on to the next slide, I wanted to touch on the threshold test. Now, for the court to grant a permanence order, there are certain thresholds that have to be met. And the court has to be satisfied that no one has the right for the child to live with them, or alternatively, where there is such a person that has a right for the child to live with them, that it is likely to be or will be seriously detrimental to the welfare for the child for them to stay there. And this serious detriment test is one that we come up against most commonly in respect of permanence orders, and particularly those permanence orders that are contested. And the serious detriment test is a factual one. It requires findings to be made on the balance of probability. And in the case of Evie, a child, Scotland, that's marked on the slides, this case considered the primacy of the threshold test when the court determines an application for a permanence order. This is the first hurdle, if you want to put it that way, that a local authority has to overcome to satisfy the court that the permanence order should be granted. It's addressed first, it must be satisfied before any other provisions within Section 84 are considered. And it's quite an odd way of doing it because the threshold test actually sits at 84D, so you would think that was a bit further down the list of priorities to be considered in the first instance, but it's not. That's the one that has to be overcome first before any further consideration can be made by the court. Once that threshold test has been met, and the court can consider that it would be seriously detrimental to the welfare of the child, then it can consider the further sections under Section 84. And the case of City of Edinburgh Council against GD, which we've mentioned here, that considered both the nature and the timing of the threshold test. In relation to the nature, the court determined that the question is whether there is a real possibility of it being seriously detrimental to the child. And it's important that this serious detriment as opposed to just detriment. It must be proven that on the balance of probabilities, there is a real possibility of the serious detriment occurring. However, the local authority does not have to prove that it's more likely than not that serious detriment would occur. And that position was further considered in Glasgow City Council petitioner in its 2019 case. And in that case, the court held that if this is the first test of the nature of the threshold test is not satisfied, then that has to lead to refusal of the entire order without further consideration. So only if the court was satisfied on the evidence that led to this primary hurdle being overcome, can the broader welfare considerations come into play? And the courts will often look at the past as being the best predicator for the future. And whilst at times this may be the case, the court has to be satisfied that there is going to be serious detriment to the child as at the date that it's making the decision. It can't look at what has happened in the past solely as being a hurdle, overcoming the hurdle for the threshold test. So if we just move on to the next slide to talk about what are the subsequent tests that the court then has to look at once you've overcome that threshold test. Well, once the threshold test has been considered, the subsequent tests that are set out in section 84 have to be considered by the court. And what they are is that a permanence order cannot be made in respect of a child who's aged 12 or older unless that child consents. And this is caveated in situations where the court is satisfied that the child is incapable of consenting to the order. However, there is a presumption of capacity which can only be displaced by proof to the contrary. The court must also take into account the views of the child before making the permanence order and taking account of the child's age and maturity so far as reasonably practical. The court must give the child the opportunity, if they so wish, to express their own views. The court will then have to have regard to any views of the child, as well as their religious persuasion, their racial origin, and cultural and linguistic background, and the effect that the making of the order will have on the child. And a child who's over the age of 12 is presumed to be of sufficient age and maturity to form a view. Then we also have the welfare test. So in considering whether to make a permanence order, and if so, what provisions that order should make, the court has to have regard to the need to safeguard and promote the welfare of the child throughout childhood as the paramount consideration. Whilst this consideration is paramount, as I've mentioned, that does follow on from the threshold test. So the court is only able to consider the need to safeguard and promote the welfare of the child once that test has been met. The case of North Lanarkshire Council against KR considered the issue of the welfare test. And in this case, it was held that the court must consider all relevant options and conduct a global and holistic evaluation of the benefits and disadvantages of each particular option, making the permanence order or not, and then weighing them against each other to determine which achieves the best interests of the child. Then there's also the minimum intervention principle, and the court must adhere to this. The court may not make a permanence order in respect of the child unless it considers that it would be better for the child for the order to be made than it should not be made. Again, this test is secondary to the threshold test. And finally, when determining an application for a permanence order, the court must also have regard to the child's religious persuasion, their racial origin, and their cultural and linguistic background when determining the application before it. I do want to just very briefly touch upon the additional tests that need to be met if the application for permanence order is also going to seek authority to adopt. And Section 80 of the 2007 Act provides that the court may make a permanence order consisting of the mandatory provisions and such ancillary provisions and Section 83, so that's authority to adopt. And the conditions to meet in order for the court to grant authority to adopt are that the local authority have to have asked for that when making the petition for the permanence order, and I'll come on to talk about the application, the court process just very shortly. The court has to be satisfied that the child has been or is likely to be placed for adoption. And the court has to be satisfied that each parent or guardian understands what the effect of making the adoption order would be and either consents to that order, or alternatively, if the court is satisfied that the parent or guardian's consent to the making of the order should be dispensed with, then it can do that. And then also the court has to consider that it would be better for the child for the authority to adopt to be made than for it not to be made. And as you can appreciate, one of the most contentious parts of those conditions is the ability to dispense with parental consent. If the court is satisfied that one of the grounds in Section 83(2) applies, then it is able to dispense with the consent of the parent or guardian in certain grounds. And these grounds are that the parent or guardian is dead, that the parent or guardian cannot be found or is incapable of giving consent, that the parent or guardian has parental rights and responsibilities, and they're not living with the child and are maintaining personal relations and direct contact. However, the court is satisfied that they're unable to satisfactorily discharge their responsibilities or exercise their rights, and they're likely to continue to do so. Or if a previous permanence order without authority to adopt has removed parental rights and responsibilities from the parent or guardian, and it's unlikely such responsibilities will be imposed on and rights given to them. Or the welfare of the child dispenses with the requirement for parental consent. The test for disposing parental consent on the grounds of welfare of the child is really very high. And also of note in terms of Section 83 and the conditions that you can consider. Under Section 93 of the 2007 Act, if a local authority has had a permanence order granted previously with certain parental rights and responsibilities being vested in the local authority, however, at that time did not seek authority to adopt, they can ultimately in the future seek to vary that permanence order to include authority to adopt. However, you would still need to make sure that you are following the particular conditions in terms of Section 83. And just finally on permanence orders, just to note that the effect of the permanence order is that the parental rights to have the child living with them are extinguished. A compulsory supervision order can then also be revoked, and a permanence order has the effect of revoking any further existing orders in terms of that in relation to Section 11 of the 1995 Act. So just very briefly want to touch on, well, once you've kind of got all of that and you think that you're going to satisfy all of those tests, well, what does the court process look like? So on a very practical level, if we just move on to the next slide, it sets out the process. So what's the appropriate court for permanence orders? Well, the appropriate court is either the Court of Session or the Sheriff Court within the sheriffdom the child resides. Where a child is not in Scotland, then the appropriate court is going to be the Court of Session. The Sheriff Court can transfer the petition to another Sheriff Court or remit matters to the Court of Session, and this is appropriate where the convenience of the parties and witnesses dictates a transfer perhaps to a different sheriffdom if the child is living somewhere else. An application for a permanence order, as I mentioned at the beginning, it can only be made by a local authority. And before issuing any application for a permanence order, the local authority should consider whether or not to seek a serial number, and that prohibits the disclosure of the child's address to any person whose consent of the making order is required. If a serial order is requested, it must be provided by the court. There are no grounds for discretion there. The petition has to be in a set form and it has to be accompanied by a report from the petitioner, and that's often referred to as a Section 80 report. If the report cannot accompany the petition, then it may be that the court will pronounce an interlocutor requiring the report to be lodged within 2 weeks or such time frame as the court may allow. On receipt of the petition, the court must appoint a curator, and if the petition seeks authority to adopt, a reporting officer. And on the lodging of the petition, the court must fix a hearing no less than 6 weeks and no more than 8 weeks from the lodging of the petition. Who does the petition need to be intimated on? Well, it has to be intimated on any person who has parental rights and responsibilities in relation to the child, and any person who claims to have an interest. However, in the case of permanence orders, which also contains authority to adopt, the petition has to be also served on the father of the child if he does not have and has never had parental rights and responsibilities in relation to the child. And so just moving on to the next slide then, please. So what does the case management of a petition look like? So once your petition's been lodged, it's been intimated, then a form of response in a form 15 should be lodged by those that the petition's been intimated on, and that has to be provided to the petitioner within 21 days. And thereafter, the petitioner has to set out a statement of facts and lodge that with the court. And what that has to do is it has to consider, the statement of facts has to set out really the decision-making process before you get to the stage of permanence order, and everything that's been taken into account by the local authority in the child's plan, which has been going on for an incredibly long period of time before we actually even get to this particular point. So we have to consider, set out the considerations under Section 14 of the Act. So that's the various duties that are placed on local authorities when coming to decisions around adoption of a child. The ancillary provisions that we talked about in terms of Section 82, the conditions in relation to Section 83 if we're looking for authority to adopt, and also conditions and considerations under Section 84 of the Act. At the preliminary hearing, the court should find out from parties anticipated length of a diet of proof, fix the diet of proof no less than 12 and no more than 16 weeks after the hearing, unless on cause shown a longer period is appropriate, and give any appropriate directions to the parties that the court thinks considers appropriate in relation to preparation for proof. So that could be the lodging of affidavit evidence or a list of agreed facts. And also it has to order answers within a period of 21 days. And at the pre-proof hearing, the court will consider the state of the preparation of the parties, the extent to which parties have complied with the orders, and really just ensure that there's efficient case management to try and secure an expeditious outcome for these children, which are the heart of these petition proceedings. So once you've got through all that process, and then perhaps the case has had to run to a full proof hearing, well, what happens then after that? So just on to the next slide, please. So at the conclusion of the proof, the sheriff can either pronounce their judgment there and then, or alternatively, they may reserve judgment and go away and provide a written judgment. If the sheriff pronounces their judgment at the conclusion of a proof, then they have to briefly state the grounds of the decision. They need to include the reasons for that decision. And if they're requested to do so, they should append a note setting out those matters, findings in fact, and also findings in fact and law. If the sheriff reserves judgment, then they must pronounce their decision within 4 weeks of the conclusion of the proof, and they also need to provide an interlocutor giving effect to the decision, incorporating findings in fact and law, and also provide a note setting out the grounds for their decision. So that is a whistle-stop tour of the permanence process, and I'm now going to hand over to Donna, who's going to talk about adoption.
Thank you very much, Fiona. Good morning, everyone. I thought it would be quite helpful to strip things back, really, and to perhaps look at some of the basics surrounding the process for adopting a child in Scotland, setting the scene, if you will, for some of the other speakers which we are going to hear from this morning. Could I have my next slide, please? Thank you. So the relevant legislation is the Adoption and Children Scotland Act 2007. The adoption process, much like the processes for permanence, which Fiona has just outlined, is a court-based process. That means that birth parents cannot enter into an agreement with the prospective adopters signing the rights to the child over to them. Only the court has the authority to grant the adoption. There are, however, various criteria which must be met before such an application to the court can be made. Firstly, the adopter must be aged 21 or over. There is, however, no upper age limit. An application can be made by a single person alone or can be made by a couple. The adopter can already be a parent, but there's no requirement that this be the case. Can I have my next slide, please? The adopter or adopters do not require to have been born in Scotland, nor do they require to be British nationals. They do, however, require to satisfy one of two criteria. They either have to A, have been habitually resident within the British Isles for at least 1 year prior to making the application. That means that they require to have lived their day-to-day lives here for at least a year. Whether someone is habitually resident here or not is a matter of fact. If that issue is in dispute, a court will look at whether they have integrated into society. Things like, have they registered at a GP's practice? Are they in employment locally? Have they bought property here? Where do the other children, or any other children that they may already have in their care, go to school? All these things will be scrutinised by the court. If they cannot satisfy that test, then the adopters must be domiciled in a part of the British Isles. That means that they must view a part of the British Isles as being the place with which they have the closest connection. Could I have my next slide, please? Thank you. A child must be at least 19 weeks old and have lived with the prospective adopter for at least 13 weeks before the prospective parents can make the application to adopt the child. A child can be adopted if they are under the age of 18. Now, that can come as a bit of a surprise to a lot of people, since the age of majority in Scotland is 16. And this, of course, contrasts even further with the position which is set out in Section 25 of the Children's Scotland Act 1995, which states that a local authority can provide accommodation for any person within their area who is at least 18 years of age, but not yet 21, if they consider that to do so would safeguard or promote their welfare. It's really easy to therefore see where confusion can creep in about when a young person is no longer eligible to be adopted. Once granted, the adoption order removes the parental rights and responsibilities held by birth parents and transfers those to the adoptive parents. Adoptive parents will have full rights and responsibilities in respect of the child, as outlined in Section 11 of the Children's Scotland Act 1995. Parental rights include the right to determine the place in which the child will reside, the right to have direct contact with the child if the child is not living with that parent, to control, direct or guide in a manner appropriate to the stage and development of the child's upbringing, and to act as a child's legal representative. The corresponding parental responsibilities include the responsibility to safeguard and promote the child's health and development and welfare. And that includes making decisions about the child's education, to provide direction and guidance to the child, to maintain personal relations and direct contact with the child on a regular basis, and to act as their legal representative. If adoptive parents separate or divorce, the parental rights and responsibilities acquired by virtue of the adoption remain in place. Could I have the next slide, please? Thank you. The adoptive child has the same entitlement to make a claim against an adoptive parent's estate as a biological child. As per the Succession Scotland Act 1964, Section 23, subsection 1, adopted children acquire rights in the estate of their adoptive parents and lose those rights in the estate of their birth parents. Distribution of an estate either under testacy or intestacy proceeds as if the adoptive child were a member of the adoptive family. Legal rights ensure that no child can be fully disinherited by their family. Legal rights exist regardless of whether the deceased person has a will. However, if the adoptive child has an entitlement under the will, as well as their legal rights entitlement, they can only claim one or the other. The choice of which to claim is theirs. Legal rights include the net movable estate of the deceased, so cash, cars, shareholding, that sort of thing, but they do not include heritable property such as land or buildings. If the deceased is survived by a spouse and their children, each of the spouse and the children are entitled to 1/3 of the net movable estate. That is to say, if there are 3 children, it is 1/3 divided amongst the 3 children. If the deceased is not survived by their spouse, only their children, then the children are entitled to a 1/2 share of the estate divided between them. Similarly, adoptive parents have rights of succession in relation to their adopted child, as if they were the child's birth parents. Interestingly, though, the devolution of any titles of honour or coats of arms continue to follow the bloodlines. People who are related by adoption do not succeed, and adopted persons do not lose rights to titles and coats of arms by virtue of adoption. It's important to make that clear to adoptive parents who already have a biological child. Adoption extinguishes the legal relationship between the child and their birth parents and creates a new relationship with the adoptive parents. It is not the intention to, if it is not the intention to sever the legal relationship between the child and their biological parents, an order under Section 11 of the Children's Scotland Act should be sought rather than an adoption. A Section 11 order allows the biological parents to retain their parental rights and responsibilities at the same time as conferring the same rights and responsibilities to the third party seeking them. Due to the legal relationship between parents and their biological children, courts are reluctant to break this bond unless there's a compelling reason to do so. Once the adoption process is completed, adoptions are usually irrevocable. One interesting quirk which I discovered is that a child who is living in a kinship placement, so a placement under Section 11, will likely still qualify for financial support for care experienced students. This also includes children in foster care, those subject to compulsory supervision orders, and those in residential care, to assist with the costs associated with university or college, should the child attend there after secondary school. There is no such scheme for children who are adopted. Could I have my next slide, please? Thank you. So looking now at the process, the prospective adopters or their solicitor will lodge an application with the court. If the application is being made to the Sheriff Court, jurisdiction to deal with the case is determined by the place in which the child has his or her habitual residence. Adoptions can also be raised in the Court of Session. The action would be raised in the Court of Session if the jurisdiction was being based on domicile. A document called a petition is drafted and lodged with the court to commence the court process. The petition sets out the details of the prospective adopters and the child, but much like Fiona described earlier, it is possible to ask for a serial number to be assigned to the case to avoid those details being made known to the birth parents. That's particularly useful if living in a smaller community where it would be much easier perhaps to track the adoptive parents and indeed the child down. The petition also contains the contact details, if known, of the child's biological parents or any other persons with parental rights and responsibilities. The name by which the child will be known if the adoption is granted will also be included. There's a checklist of productions contained within the petition, and that sets out the documents which must be lodged at court with the petition. And the list states that these are the child's birth certificate, the marriage certificate or civil partnership certificate of the prospective adopters, if applicable, a consent form signed by the natural parents, if that is available, and or the child's guardian. And if a child is over the age of 12 years, then a consent form signed by the child. Much like Fiona has described earlier, a child cannot be adopted if they are over the age of 12 years without providing their consent, unless the court is satisfied that they do not have the capacity to provide that consent. If applicable, a permanence order with authority for adoption must be produced, as well as, again, if applicable, an order freeing the child for adoption. There should also be lodged an acknowledgement by the local authority to say that they have been told that this adoption has been applied for, if the child is being looked at for adoption by the local authority. If the child has been placed for adoption by an adoption agency, then a Section 17 report will require to be lodged with the petition. And if the child has been placed for adoption through the local authority, then the local authority will provide a report under Section 19. And I'll go on to look at that in a moment. A copy of the adoption application is sent to the child's parents. Sometimes, in my experience, it can be quite tricky to locate birth parents. Often they're leading quite chaotic lives and they can move addresses frequently. But nevertheless, attempts to locate the child's birth parents must be made. A tracing agent can be instructed to locate the parents and to serve papers on them if necessary. Or sheriff officers can be used to serve the papers. The court must be satisfied that all reasonable attempts have been made to locate the birth parents. The birth parents have 21 days from receiving the papers to oppose the application, and they do that by lodging a form of response with the court. A preliminary hearing will then be assigned for around 6 to 8 weeks after the application has been lodged, regardless of whether or not the application has been opposed. I mentioned a moment ago that there are reports which need to accompany your petition when lodging it with the court. If the child's been placed for adoption by an adoption agency, the agency will have to produce a Section 17 report. And the report will cover the child's background and the background of the prospective adopters. Alternatively, if the child has not been placed with the adopter by an adoption agency, notice of the proposed adoption must be given to the local authority under Section 18 of the Act, and the adoption cannot be granted unless the local authority has been given 3 months' notice of the intention to adopt. The local authority will then prepare a Section 19 report, which is the equivalent of the Section 17 report I just mentioned, which will set out the background information relating to the child and the prospective adopter or adopters. Separately, a curator ad litem is appointed by the court to investigate matters and to provide a report to the court in advance of the preliminary hearing. So the curator ad litem is really the eyes and ears of the court, and it's their job to tell the court all about the background of what they have found when visiting with the prospective adopters and meeting with the child. Can we have the next slide, please? The child's views must be taken if the child is old enough or mature enough to express a view. The curator ad litem will meet with the adopters and will provide information to the court regarding the circumstances of the adoptive parents and the child. If the action is undefended, or if the court dispenses with the consent of the birth parents, the court may grant the adoption order at the preliminary hearing, if appropriate to do so. Consent can be dispensed with if the birth parent has died, cannot be found, is incapable of consenting, or cannot satisfactorily discharge their parental rights and responsibilities, or indeed if the child's welfare requires that it be dispensed with. If the action is defended, the prospective adopter will need to lodge a statement of facts with the court. The defender lodges answers. The court fixes a timetable for further court procedure, which will lead to a diet of proof. The proof, as Fiona has explained, is the final hearing in an adoption case. At the proof, evidence will be led on behalf of the adopters to support their case. This will include oral evidence from the adopters covering such matters as what the current arrangements are for the child, the relationship with the child, and what the arrangements will be if the adoption is granted. In response, the birth parents will be given an opportunity to provide evidence regarding their circumstances, their relationship with the child, and what that ought to look like going forward. The court will then decide whether the adoption order should be granted. The only real matter to be determined by the court is what is in the child's best interests. If the order is granted, the court will also decide on post-adoption contact between the child and birth parents. That is a really complex issue and will be covered in a later session this morning. If adoption is granted, the adoptive parents then become the child's legal parents. Following on from the adoption being granted, the court will send the adoption order to the Registrar General. A new birth certificate is then issued in the child's new name, and the original entry in the Register of Births is sealed. Now, that was really all that I wanted to cover this morning. I can see that the chat box has now been made available for questions and answers, a question, to be raised with this that hopefully we can answer. There have been one or two come in already. I'm just going to have a little look through some of these and see if there's any that we should answer now. I'd note that there's perhaps one or two that would be better saved for later this morning for the general session at the end. But I see one here. Someone has asked, I'm going to keep it anonymous so that everyone feels more confident about asking questions. But someone has asked, on what grounds would a sheriff refuse an order seeking adoption where the adoption petition has not been defended? So I'm reading that to be on what grounds could a sheriff still refuse to grant an adoption if the birth parents have not opposed the application? So one obvious way in which a sheriff would have to refuse to grant the adoption would be if a child over 12 who has the capacity to give consent has refused or declined to do so, because the adoption quite simply cannot proceed on that basis. But more generally, once the adoption petition is lodged, the court will have the curator ad litem appointed, and the curator ad litem will have to make all these inquiries that I mentioned earlier. And in order to persuade the sheriff to grant the adoption, the sheriff would have to be satisfied that it was in the child's best interests for the adoption to proceed. And regardless of the fact that the biological parents may be in agreement with the adoption taking place by a certain individual or by a couple, a sheriff would still refuse that application if he or she felt that it wasn't in the child's best interest to be placed with those particular individuals and that the adoption just should not proceed. What else do we have here? Oh, this is an interesting one. So the question is, if an adoption order is refused, can a potential adopter reapply for the adoption order in respect of the same child at a later date? I think the short answer here is that the court has discretion. In terms of Section 33 of the Adoption and Children Scotland Act 2007, it's stated that the court may not hear an application for an order in relation to the child for adoption where a previous application has been made in relation to that child by the same persons if that earlier application has been refused, unless the court has directed at that earlier application that Section 33 should not apply, or indeed if it appears to the court that there has been some material change in circumstances. The obvious thing that I can think about in that scenario is perhaps where the initial adoption was refused because the birth parents had convinced the court that they may soon be in a position to exercise their parental rights and responsibilities, but now after the passage of time it's become apparent that that's not something that they're going to be capable of managing. Or, the sheriff, though, does still have overriding powers. And if the sheriff thinks that he or she ought to, then the sheriff could ultimately consider the application again at a later date. I wonder if there's any other questions right now that we should perhaps look at just now. Oh, here's an interesting one, which is, what are the biggest challenges facing solicitors when dealing with adoptions or permanence cases? I'll perhaps pass that one on to you, Fiona, if you don't mind to answer.
Sure. I mean, I suppose this is quite a cop-out answer. Each case will turn on its merits, I suppose. So it'll be very much dependent on what the circumstances are of the case. I think from a permanence order perspective, by the time it gets to the stage of an application being made for a permanence order with or without authority to adopt, there's been quite a lot of work done by the social work teams and the in-house legal teams of local authorities to kind of help make these children's plans and kind of decide what's going to happen. But unfortunately, a lot of the time, and as Donna mentioned earlier, there can be quite a chaotic lifestyle in the background with the birth parents. And unfortunately, by the time we get to the court stage, generally that relationship between the birth parents and the local authority is completely broken down. So it can be it can feel very adversarial. And obviously there's a lot of emotions involved in respect of these cases. And I think what's important is that when you have your legal team involved, is that those lawyers are coming in with a level head and we're looking at working collaboratively of what's in the best interests of the child. And ultimately, you can generally get to a point that everybody can get on the same page. Don't get me wrong, there are times that just that isn't possible and you do have to go through a full proof. But the most difficult thing from permanence order perspective is just overcoming that threshold test and the serious detriment, and then also dispensing with the consent of the birth parents if that just isn't forthcoming where there's authority to adopt.
Thanks, Fiona. I think the only thing that I would add to that is that there's the obvious tension between right to family life and the protection of the child. And I think the other issue that certainly one that's becoming more and more prolific for us practicing in all areas of family law really is confidentiality. In this digital age, it's far easier to track people down via social media and to locate people who previously may not have been capable of being located. So we have to be very mindful of that and how that all fits together with the various safeguarding protection issues that we're also grappling with. I'm looking at the time and I think it's time for me to hand back to one of my colleagues. So I'm going to hand over now to Gary Sturrock, who is a Senior Associate in the Family Law team.
Thank you, Donna. I'm pleased to welcome our next speaker, Isabella Ennis KC. After a career in private practice, Isabella called to the bar in 1993. Isabella's civil practice at the bar has been varied, but it has primarily focused on child law and family law and also personal injury reparation work. Isabella gained considerable court experience, including appearing in House of Lords and appearing in notable fatal accident inquiries. Isabella was appointed as Crown Counsel at Crown Office and Procurator Fiscal Service in 2021. She took silk in 2022 and was promoted to Senior Advocate Depute in 2023. Having completed 3 years as an Advocate Depute, she's returning to private practice in January 2025. Isabella has built a reputation for her expertise in complex family law matters, including high-value divorce cases, international child relocation disputes under the Hague Convention, and relevant to today's purposes, adoption proceedings. Her work often involves representing parties in sensitive child law cases, such as those involving compulsory care measures. Isabella is an accredited family law arbitrator, and she sits on the Family Law Arbitration Group Scotland's National Committee. I'll now pass you over to Isabella.
Good morning, and many thanks for inviting me to speak with you this morning. Thank you, Gary, for those kind words. I can't tell you how relieved I am to be returning to the safe and known shores of family law after my stint as Crown Counsel. If I could have the next slide, please. Now, you've already had a talk on permanence orders, and so this is just a very short recap on that in order to put into context the case law. So, as you've heard, and I'm just going to whiz through this quickly, permanence orders can allow for post-adoption contact, and it's generally the way in which an order for adoption would arise post-permanence order with authority to adopt having been granted. Permanence orders were introduced as part 2 of the Adoption and Children Scotland Act 2007. Before that, there was legislation and there were freeing for adoption orders, and the 2007 Act was thought to be an innovative and modern step forward. In terms of Section 80 of the 2007 Act, only a local authority may apply for a permanence order in respect of a child. There is no requirement on the local authority to explore alternatives to the permanence order, although that is not the case when seeking an adoption order. Consideration of reasonable alternatives to a permanence order should, I say, be part of a general assessment of welfare when the local authority is considering the permanence order. Well, it's not obliged to, it's good practice to have considered those options. And it should be part of the assessment under the regulations. In any event, it's clear from the recent case law, I say, that the local authority is going to be unlikely to be able to persuade a sheriff or a judge that it would be better for the order to be made than none to be made at all, including kinship care orders, if they haven't explored whether those are available and realistic options for them. If we could have the next slide, please. So the general conditions before granting a permanence order, again, we'll just race through these because you've already had a discussion about them. Local authorities' sole ability to apply for them, that's Section 80, subsection 1 of the 2007 Act. The child over whom the permanence order is sought must not have been married or be in a civil partnership. And it's important to note that a permanence order may be made in respect of a child who's already been adopted. The child must be under 16 at the time of the grant of the order. And that was recently discussed in the case of Glasgow City Council against MM, and the citation is there. MM had a range of cases and disputes with Glasgow City Council, and there are 2 reported decisions in 2024 before the Sheriff's Appeal Court. So it was a litigious set of circumstances that led to 2 important cases, one you've just heard about, and the other that the child must be under 16 at the time of the grant of at the time that you seek the application. If we could have the next slide, please. So again, you've already heard about this. The views of the child being sought in any application for a permanence order, and we'll come on to discuss those in the context of adoption, is embedded within the 2007 Act, but the UNCRC, United Nations Convention on the Rights of the Child, have strengthened and potentially emboldened those obligations. They've been imposed under the Children's Scotland Act in 1995. So that's nearly 30 years we've had those obligations incumbent upon us as family lawyers. And we've got used increasingly over time to implementing that obligation in more than just a cursory fashion. Local authorities should have regard to the child's views, and their obligation is, so far as reasonably practicable, in terms of the 2007 Act. I would have concerns that, in terms of the Children's Scotland Act, I would have concerns that the UNCRC obligations that impose upon the local authority a duty to act in a compliant fashion go further than reasonable practicability. Article 12 of UNCRC words the obligation as a shall obligation and requires the views of the child to be taken and then to be given due weight in accordance with age and maturity. It's also an obligation under UNCRC that not only has that Article 12 obligation been fulfilled, but that it has been recorded as having been done, and the reasons behind the weight attached to it require to be noted and recorded. So whilst the curator ad litem will be doing it once you've lodged your application, both in terms of permanence orders and adoption orders, before seeking those views, the obligation incumbent upon the local authority should be Article 12 compliant. You should be seeking the views of the child so far as the views of that child are able to be expressed, and you need to record them, and you need to then record the weight that you have attached to those views, setting out the reasons why you have attached little or no weight to it, if that's the case or not. If we could have the next slide, please. So as you've heard, the provisions of a permanence order, it requires to have the mandatory provisions and such ancillary provisions as the court thinks fit, and if applicable, authority to adopt in terms of Section 83. The ancillary provision includes the order for contact following the grant of any permanence order. If we could have the next slide, please. The reason why the ancillary order for a grant of contact becomes important is, as I've said, the permanence order is often the first stepping stone to an adoption. And therefore, if there is a grant of contact in the permanence order, then that will have a practical, influential colour to any adoption order going forward. It also means that any adoption order going forward will have to be intimated to the natural parents for them to participate in any adoption process, if so minded. But it will be difficult if these follow on quickly from one another to escape the fact that a court, in granting that permanence order with authority to adopt and an ancillary provision for contact, has made that decision having regard to recent evidence and the welfare test. Because in granting any order for contact, the court can only do so if it considers that it's in the best interest of the child, having regard to the child's welfare as the paramount consideration. Contact as an ancillary provision is welfare driven. And that has been the subject, rather surprisingly, I have to say, of recent discussion, again in the Sheriff Appeal Court. And if we could have the next slide, please. It was most recently discussed in the case of East Lothian Council against L, and that was just last year before the Sheriff's Appeal Court. Although no authority to adopt was sought in that action, the Sheriff's Appeal Court relied upon post-adoption contact cases for guidance, because there isn't a lot in permanence order applications providing guidance on that. And one might have thought that that was because it was a fairly plain and simple and obvious test contained within the statutory provision. In any event, the Sheriff's Appeal Court thought it was important to go through and discuss where it relied upon for its view and how that would impact upon cases going forward. And it was keen, I think, when you read the judgment, to ensure that there was crystal clear clarity. So, East Lothian Council against L. L was born in October 2010. He lived initially with his parents and siblings until 2015, when rather the wheels came off in the family home. His father was convicted of a range of offences leading to his imprisonment. Those offences included sexual offending and led to him being placed on the sex offenders register, and that was for a period of 5 years. At that point, the social work department became engaged in L's family, and it is fair to say that it was not a particularly high quality or cooperative level of engagement. Within a year, L had been moved out of the family home and into a foster placement. Now, part of that, if you read the judgment, is due to, I think, a difficulty between L's mother and the social workers engaged in the case. It wasn't helped by L's father. But I think it was also significant that L had, or was then diagnosed during the course of the time when the social work department became involved, and before he went to foster parents, he was diagnosed with autism. And he was considered to have quite significantly poor levels of communication, interaction, and development. And so the social work department were very concerned about the impact of his autism and his communication difficulties. And those were significant drivers towards moving him into foster care. Once he was in foster care, that required him to be made the subject of a compulsory supervision order. The residence was with those foster parents, and all of this shows that within a very short time, things had become very difficult between the social work department and L's natural parents. Notwithstanding that, L had, or the child of L had, fortnightly direct face-to-face contact with his parents from 2016 until 2022. That's a significant length of time. In the middle week, he also had unsupervised direct contact with his siblings. By March 2022, the relationship between the parents, by this time, the actual father, was out of prison, and the social work department, and to an extent the foster parents, had deteriorated to such a level that the local authority applied for a permanence order. That was made with ancillary provision in respect of contact, and it was made just before L's 12th birthday. L was living with the same foster family since 2006. The permanence order would allow him to continue to live in family with that foster family. But the level of contact ordered in the permanence order was a massive reduction on that which had been exercised up until the grant of the permanence order. And that was supervised biannual contact with his parents. So it went from twice a month to twice a year. And he could have contact with his siblings, but that was at the discretion of the social work department. It came as no surprise, I'm sure, to everyone involved in the case that it went to the Sheriff's Appeal Court, the parents and siblings separately appealing that grant of contact. What they appealed on the basis of was that the learned sheriff had misunderstood or confused the consequences of a permanence order with an adoption order and had thus confused the application of the welfare test when applying it to a permanence order. And the reason for that, and we'll come on to look at those cases, is because of his use of post-adoption cases to weigh in the balance. The SAC, in its judgment, though, was having none of it and said that it was quite clear when you read the sheriff's judgment properly and read the essentially the edited highlights of it, that the learned sheriff was quite clear that the relevant test to be applied in any question of parental continuing contact after the making of a permanence order is that of the welfare of the child. The Sheriff's Appeal Court then went on to discuss the cases where post-adoption contact had been considered in order to be reinforcing of its view that the welfare test was the only test to be applied when considering the question of contact in permanence orders. And it approved very specifically of the carrying through of the contact provisions or the jurisprudence in post-adoption cases into permanence order cases. And so it had a discussion firstly of a 2019 case, and if we could have the next slide, please. So in 2019 case is ABA and CD against LM, and it's reported at 2019 Family Law Reports, page 60. It's also a decision of the Sheriff's Appeal Court. And this was a case where the mother of 3 children who was not opposing the adoption, and the adoption was, I think it was post-permanence order, but I could be wrong about that. Anyway, she wasn't opposing the order for adoption, but she was opposing the lack of any post-adoption contact. And in fact, all she wanted was indirect letterbox contact, which was refused at first instance. And that decision was then appealed to the Sheriff's Appeal Court. And in AB, the Sheriff's Appeal Court looked to the case of B against C, 1996 Scots Law Times 1370. This is an interesting case because, first of all, it's a very old case. It was under the old legislation. And it considered the context in a very different climate. And one would have liked to have thought that by the time we were getting to 2023, which is when the Sheriff's Appeal Court are looking at this and approving of the 2019 case and the 1996 case, they might have thought that modern sensibilities about post-adoption contact would have influenced how they read B against C. But no, they were having none of it. AB quoted the Lord President in B against C, and in our 2023 case, the Sheriff's Appeal Court approved of that approach too. The Lord President in B against C, and it's a well-known paragraph, I think, said, Conditions expressed in favour of third parties, which might make it necessary for the court to become involved in the making of further orders with a view to the child's welfare, will not be appropriate except in the very rare cases where the child's welfare might be prejudiced if a condition to that effect were not to be made. As Lord Ackner observed in Ray C., in normal circumstances, it is desirable that there should be a complete break from the child's natural family. But each case must be considered on its own facts, and we are in no doubt that the highly unusual background to this case makes such a condition desirable in order to provide support and guidance to all those involved, and above all to the petitioner in this very difficult decision which now lies ahead if the child's welfare is to be safeguarded throughout her childhood. In the normal course, there will be no such contact. In each case where the matter is put at issue, the court must determine the matter in the best interests of the child concerned, considering whether such contact will safeguard and promote the welfare of the child throughout the child's life. Paragraph 33 is the Sheriff's Appeal Court. The earlier paragraph is B against C. B against C was thought to provide a basis for saying that there should be an exceptionality test to contact. And there were a whole series of cases in the early 2000s where there was a discussion about exceptionality. Because B against C was a very rare case in exceptional circumstances where post-adoption contact was granted, it was taken to be that such exceptional circumstances had to exist. That was roundly disputed or rejected by the time now Sheriff Principal Anwar considered the matter in P against D, which is in 20th July 2016. It is not a reported case. It was when Sheriff Principal Anwar was a sheriff, and it didn't go to the appeal court. However, it has been relied upon by the Sheriff's Appeal Court in both the 2019 case and the 2023 case as setting out a clear statement of how we should apply the welfare test to post-adoption contact. If anyone's interested, B against C, the exceptionality of that case was that the child's mother suffered from a very rare and genetic degenerative illness, which the child had a high chance of also contracting, and it was considered necessary for that child's welfare that they had an understanding of their mother's life and the consequences of any potential genetic illness, so that should they be struck down with it, they would be in a position to manage that better. And everyone knew that, which was why there was this drive to the exceptionality test, which was ultimately rejected. And if we could have the next slide, please. So P against D, Sheriff Anwar's decision before becoming Sheriff Principal. This was a direct application for adoption of a child who was 4.5. There had been no permanence order with authority to adopt sought prior to that. The child had had a complex early life. The child's mother had had considerable problems in her early life with criminality and drugs. The gran had been peripherally involved at stages with the child. Both the natural mother, the father whose name was not on the birth certificate, and the gran sought to resist the grant of adoption. What they sought was that the adoption order should be refused, and that at the very most what should be granted was a lesser Section 11 order in terms of the Children's Scotland Act. And they also sought direct supervised contact to the child. The Sheriff Anwar's judgment runs to, it's over 50 pages, and there are very clear findings in fact which make pretty difficult reading, I think, for the child's family. They plainly didn't come across terribly well with Sheriff Anwar. She granted the order for adoption and she refused any order for contact, any order at all. She considered B against C, and she also considered in some detail a review of earlier cases which led to 2016 when she was then making a decision. And so you can see her go carefully through decisions made by the now Sheriff Principal of Edinburgh, by Sheriff Morrison, by a range of carefully thought through decisions, which she takes into account in forming her view, and in particular coming to the view which has been approved subsequently, where she says at paragraph 108, "In my respectful judgment, the Inner House in B against C was not laying down a threshold test for post-adoption contact as being whether there existed exceptional circumstances, but was rather emphasising the need for the decision maker to have at the forefront of his or her mind the guiding principle that adoption provides complete security to the child by making the child part of the adoptive parent's family. The court was seeking to emphasise that conditions should not be attached to adoption orders as a matter of course. Each case must be decided on its own facts, and it is clear, in my judgment, that a departure from normal circumstances in which it is desirable that there should be a complete break from the child's natural family will be justified only where it is established that it is in the best interests of the child to do so." She went on at paragraph 111. "Whether an order for post-adoption contact is in the best interests of a child requires a balancing exercise between securing finality and security for the child on the one hand, and maintaining some link with his or her birth family where that is considered appropriate on the other." She then went on to provide a form of checklist where she set out 8 considerations which should be weighed. And we're about to go through those, but those 8 considerations are repeated in our most recent case that we looked at in 2023 and in the 2019 case. So her 8 considerations are approved of at appellate level and therefore must be considered to have quite a lot of weight. So if we could have the next slide, please. So here are her 8 considerations, and they're set out at paragraph 112. She says, "These are the considerations to be weighed in the balance when considering post-adoption contact and whether it meets the welfare test," which is, of course, throughout life when we're looking at adoption. When I was reading these, I was struck by how similar they are to any considerations which the family lawyers listening to this would naturally take into account in any contact dispute. And I was surprised that it was felt necessary to set them out so clearly and then for the Sheriff's Appeal Court on 2 successive occasions to approve of them in the context of post-adoption contact. And I think that's, I mean, my personal view is that I wonder if that is because the Sheriff's Appeal Court is setting a benchmark of clarity that contact post-adoption is not going to be the norm, is not going to be moving in the same direction as perhaps we might think it should or it is in England. It's interesting that whilst the 2023 case that we've just looked at, just after it was issued, the previous president of the family division in England Sir Andrew McFarlane was giving a Mayflower lecture in November 2023 about the balancing exercise for post-adoption contact. And the tenor of that lecture was very much looking at the weight that had to be attached to, as Sheriff Principal Anwar commented, on maintaining links with his or her birth family. And Sir Andrew McFarlane was heavily of the view that that was a consideration which, when weighed in the balance, carried significant weight. So I think it's important that we look at Sheriff Principal Anwar's 8 factors in light of Sir Andrew McFarlane's views and in light of how we would view these if we were looking at them in the context of a family law contact dispute. The first one, the nature of the child's bond with and the attachments to members of the birth family seeking contact. That is self-evidently a necessary criteria for considering any action for contact. The fact that on post-adoption that contact with the birth family is severed for all time coming means that the attachment that the child has, the bonds and attachments with the birth family, is a significant one to consider, and the breach of that must be considered, the breach for all time coming, and the impact that may or may not have on the child. So in these cases, you must be looking to see what the relationship is, what the quality of the relationship is, the extent to which that has existed with any particular or all members of the family, what the age of the child is and the impact that that will have if it was severed, as well as the quality of it currently. Number 2 isn't a welfare consideration. We've discussed that, the age and if appropriate, the views of the child. As family lawyers will know, the views of the child and the weight to be attached to them is a question of the age and understanding of the child, but the age and understanding of the child, the courts have over the years considered to have been going down and down and down and down. When I started doing family law, no one really had much regard for what a child under 12 said at all, and not a whole lot of regard for an over 12-year-old. Now, especially if we look at international child abduction, the courts are looking at the views of really very small children. In seeking any order or considering any petition for adoption, the local authority, if it is advancing that petition, or the prospective adopters, when they are, really have to have regard to the views of the child, and those have to be independently obtained, and a careful analysis of the weight to be attached to them should be included on any expression of those views. The nature and level of contact currently enjoyed by the birth family, if any, that's plainly a welfare test. That's plainly one that family lawyers are entirely familiar with. Family lawyers would view that as a status issue. You're not going to change, or you're going to be struggling to persuade a sheriff or a judge to move from an established pattern of contact to alter the status quo, and you would have to demonstrate that that was in the best interest of the child, having regard to the child's welfare. And I think we need to bear in mind that currently, I don't think that's what Sheriff Anwar meant. I think she was looking at it from a less positive status quo perspective. And we see that from number 5, which is the risk the child may be exposed to during such contact, if any, and that is a frequent factor in these sorts of cases. The ability or otherwise of the birth family to commit to contact and heed the advice of professionals in relation to how such contact might be managed. And number 7, the ability of the birth family to accept the terms of the adoption order, to be supportive of it, and to refrain from undermining it. Those are important welfare considerations, and those are unique, I think, to post-adoption contact rather than family law contact. Although, of course, the general child welfare thinking would be that any parent who was unable to support the welfare of their child in the context of any court order would be viewed with some disapproval by any judge or sheriff. Sheriff Anwar's 8 factors should not, I say, be seen as an exhaustive list so far as welfare is concerned, notwithstanding that in 2023 the Sheriff's Appeal Court approved of this list. There is a great deal more to it. What I think is an important factor that's missing from that, and if we turn to the next slide, and I realise I'm just about to run over my time, so we'll just whiz through these. The points to ponder from those 8 factors. It's clear there's no exceptionality test. We've discussed that. The welfare of the child is the paramount consideration. We've discussed that. Sheriff Anwar has set out her 8 considerations for weighing that. Importantly, each case must be fact-specific. In considering the welfare test, it must be judged in the context of the whole life of the child. There must be evidence which the court accepts, which supports any order for contact meeting that test. That must mean that when the court is considering Sheriff Principal Anwar's 8 points, there was a specific order for contact that was sought, which could be tested against those 8 points. You cannot be seeking to establish an order for contact in a vacuum. You have to work out what order you're looking for, how that's going to be implemented. Therefore, what are the views of the prospective adopters and the child on the specifics of that order, and how do those impact on Sheriff Principal Anwar's welfare points? When you're looking at the views of the prospective adopters, they have to understand not just what the proposed contact would look like, but how they view interacting with the natural parents. The natural parents have to support the order for adoption, but the prospective adopters have to be able to support the order for contact if it was made and not undermine it either. And your evidence must include the views of the child if appropriate. Those are, of course, the curator ad litem report will be in there for the child come your adoption petition being lodged, but you have to have thought about it before you even lodge the petition. Thank you. I'm sorry I ran over. Gary.
Isabella, there's a couple of questions that might be of assistance for the audience that you might be able to help with. One of those questions, Isabella, is what do you see as the merits of a POAA versus adoption in cases for looked after children? And I guess that could probably be answered in 2 parts. What are the benefits to the local authority, and what are the benefits potentially then to the prospective adopters and birth parents? There's different angles. You might be able to tackle that question.
Yeah, so I think the benefits are entirely dependent on where you're standing. If you are the local authority, then the benefits to you are, I think, that you enable the child to be placed with the prospective adoptive family, for that to bed in, for the natural family to be distanced from it, and for the local authority to have a degree of surety that the adoption order that then follows from that, it's never rubber stamped, but it's certainly typically a more straightforward process. A direct adoption petition exposes the prospective adopters to all the difficulties and vagaries, if opposed, that the local authority might have encountered in a permanence order application. So if you don't go through the permanence order with authority to adopt and then the adoption application, the local authority is asking quite a lot of the prospective adopters in a direct application to face that hurdle. And also, if there is going to be post-adoption contact, to set up both of those sides in high conflict dispute is not a good recipe for any post-adoption contact application working. So there's a lot to be said for the local authority going through the two stages. I think it probably makes life a lot cleaner for the prospective adopters and gives them security as well. For the birth parents, I don't think there are any advantages at all to either process, and there are significant disadvantages in the permanence order because they may think and feel that having failed to resist the permanence order or only establishing letterbox contact in the adoption, in the permanence order, they have no realistic prospect of achieving that continuing in any adoption application that would follow. So the colour of the contact in a permanence order, I think, is highly significant when you play that through into an adoption that would follow a permanence order. So the natural parents probably have more chance of success in securing contact in a direct petition, if they have any chance at all.
The other thing maybe, Isabella, then is just turning our mind to the different legal tests that are applied with a POAA and a direct petition for adoption. Do you see there being any sort of marked differences between the two in terms of advantages to either process to achieve the ultimate outcome of adoption?
Well, obviously the legal tests are different for a permanence order with authority to adopt and an adoption order. I'm not sure that either way, you have to, once you get to adoption, you have to meet the same legal criteria. It doesn't matter whether that's at what stage you're looking at it. Adoption is adoption. I think the factual matrix influences the application of the legal test. And by having a permanence order, you significantly change the factual matrix and therefore change the way in which that is applied when you get to the adoption.
There's just one more quick question you might be able to answer before we move on. The question really was around your chat about the views of the child. And a question has been raised in relation to if a child is 12 or over, is a child informed that they can seek legal advice and representation? So it's quite a good question, in fact.
Well, you can't have a permanence order or an adoption order without the consent of a child who's 12 or over. If I was acting for the local authority in the permanence order or the parents in the prospective adoption order, before I moved to court, I would absolutely be saying to the 12-year-old, this is what I want to discuss with you. I want to take your views on it. If you have any views, I'll have this chat. But actually, what I think you should do after this chat is have a think about whether you want independent representation, and I'll sort that out. And it's then for that child's solicitor to weigh in the balance whether they consider the child is capable of giving instructions. And I think for most solicitors with most 12-year-olds, they would be of the view that the child could. And then the child can, that doesn't mean the child's entering the process, but it does mean that the child is in a space to make an informed decision about the pros and cons of that decision.
Back, everybody. It is now my pleasure to introduce Dr. Chris Burke, who is our final speaker of the day. Chris will be known to many of you. He is a clinical psychologist who regularly provides expert witness psychological opinion within the areas of child and family law to the court and children's panels across Scotland. He is frequently instructed to assess the impact of residential and contact arrangements upon the psychological well-being of the child. Chris provides training and consultation to legal decision makers, practitioners, and looked after children and caregivers, such as adopters and kinship carers and foster carers. This helps them to develop the understanding of the benefits and risks associated with what contact means to the child. Alongside his colleague Dr. Anne Woodhouse, who will also be known to many of you, Chris has developed the Safe and Meaningful Contact Guidelines to identify whether the contact system is being appropriately supported to achieve safe and meaningful contact for children. And I'll now pass over to you, Chris. Thank you.
That's great. Thank you very much, Sarah. Thanks for that introduction. And thank you also to Brodies solicitors for inviting me to come here and speak today. So today I'm going to be talking about psychological considerations to inform decision-making about post-adoption contact. So as Sarah said, I'm an independent clinical psychologist. I provide expert witness for the family courts, offering opinion related to both residential and contact arrangements in both private and public law cases. And I approach this today drawing on my background of working clinically with traumatized children and children living in care. And it's this clinical experience of trying to understand and support the developmental needs of children and young people that really informs my talk. And I want to share with you what I want to know as a clinical psychologist when considering whether contact arrangements will be safe and meaningful for children and young people who have been or are being adopted. Just a quick note on the word contact. It's a universally recognized term, but it's not a relational term. So what we're actually talking about is helping children maintain relationships or connections with their birth family, as long as that's safe for them to do so, because that is such an important aspect of their long-term development. So the aims of the talk today, I'm going to be talking for about 45 minutes. I want to make the links between contact arrangements and the child's developmental recovery needs. So we'll look at what are the psychological needs of the child or the young person in care. Then we'll consider how does contact impact upon these needs. And I really want to emphasize the crucial role of appropriate support for all of the contact system, the child, the carer, and the birth relative, to ensure that contact is safe and meaningful. And when I talk about support, I mean how contact can be carefully planned and managed to maximize its benefits and minimize any risks for the child. And then finally, I'll briefly introduce a framework to aid decision-making, the Safe and Meaningful Contact Guidelines. So the SAMC guidelines have been developed to help the user organize decisions about contact around the needs of the child. Okay, so just to kick things off, I want to do a quick poll, and I want you to just respond. Hopefully this will pop up on your screens. Yep, here we go. So just indicate whether you agree or disagree. Post-adoption contact arrangements should be determined by the wish of the adopter. Some of you responded incredibly quickly to that. There's still some responses coming in. Okay, I'm assuming that everyone can see the results there. Well, actually, I can press on. There you go, share results. So yeah, disagree is 90%, agree is 10%. Okay. All right, so Obviously, that's a bit of a forced choice. And we obviously try and judge everything on a case-by-case basis. But generally speaking, while the view of the adopter is very important, we can't assume they know what's best for the child unless they fully understand the complex issues. Like the rest of the system around the child, adopters need appropriate support to understand how contact has the potential to benefit their relationship with their child, as long as it's safe. Risks come if adopters wish to deny the child's dual identity, that they have two families. So if adopters and the system around them and the child avoid thinking about the child's birth family, will really risk psychologically harming their child. So I'm kind of pleased to see that it was such a high percentage of disagree with that. Because really contact is not simply time for the child and birth relative to be together. It's not just about putting them in the same room. It needs to be more than a mechanical or routine arrangement, which only provides for physical proximity, but little in the way of an emotional encounter. Sometimes contact is instigated without careful consideration of what it means to the child and without the right support for the contact system to make it meaningful. And as a result, contact that may have benefited the child could unnecessarily at times be stopped, or unsafe contact might be continued. So to orientate us to where contact fits with the child's emotional needs, I want to discuss the psychological needs of the child and the young person in care. And I'm just going to do that through a quick kind of case example. And this is just a totally made up example. I'm going to call the child Thomas, and Thomas is now 4 years old. Thomas was removed from his mother's care at the age of 2. This was due to exposure to domestic violence, substance misuse and neglect, and his father was never involved in his care. He was initially placed in short-term foster care. He was then returned to his mother after 6 weeks, following her making some changes in her life, but this broke down again after 1 month. The child was then placed with different short-term foster carers for a period of 20 months, and he's nearly 4 by the time he's moved to live with his adopters. So just by the time the child's reached permanent care, he's likely to have experienced maltreatment whilst living with his birth mum, separation from his birth mum and then from various carers afterwards, experiences of loss, experiences of rejection. He'll have confusion about caregivers' consistency and their long-term availability, and likely to have confusion about who he is, where he belongs, and whose fault it is that he's not wanted. So how do these experiences impact upon Thomas's understanding of himself and the world? How might his experience of past relationships impact upon his expectations of his relationship with his adopters? So because of his experience, he's likely to have a model of representation of others in his mind as people who hurt him, people are unpredictable, people are likely to reject me, and that people can't be trusted. He's also likely to blame himself for being bad, unlovable, and for not being wanted. And his understanding and representation of the world around him is that it's an unsafe place, the world's confusing and not safe for him to be in. So this is essentially the child's internal working model of relationships. It underpins his expectations of relationships. So the internal working model underpins attachment patterns. And unfortunately, research informs us that these harmful patterns of early relationships become hardwired in the child's brain. So care relationships become associated with neglect, with abuse, both physical and/or sexual abuse, and separation, loss, and rejection. And what I'm talking about here is essentially attachment trauma. It's being harmed by people who were meant to care for the child. So the child has limited experience of consistent, safe care. And it's not just frightening experiences or events of abuse or neglect that are traumatic. The trauma for the child is being left alone to deal with their fears, because the main carer, the main source of any comfort, is also the source of the fear. So they've been through difficult events, but there's been no one there to support them through it. A child's less likely to become traumatized if they go through difficult events, but they're in the context of safe, nurturing relationships. So because of this, they've got a limited ability to regulate their overwhelming feelings of fear, loss, rejection, and confusion. So then they'll cope with primitive fight, flight, freeze, survival behaviors. So they might be emotionally avoidant, cut off their feelings, make themselves numb, which could lead to self-harm, to taking drugs. They might exist in a kind of dissociated state where the world is not really reality, more of a fantasy in their mind. They might become aggressive, act out their difficult feelings, become disruptive. I'll reject you before you reject me, or a combination of all of these different ways of trying to cope, which we'll often describe as challenging behaviors, but they are in fact the child's survival behaviors. So then when a traumatized child reaches permanent care and a permanent care arrangement, there's often the hope that with love and affection from the new carers, the child will now be fine. The forever family ideal, or perhaps fantasy, the child will be safe and filled up with a healthy relationship. And unhealthy past relationships will all be washed away. So this may be the hope of the carer or the adopter. Perhaps it would be the hope of the court and even the social worker perhaps closing the case at the point that the child is adopted. But unfortunately, it's not as simple as that, because the child's brain is hardwired to expect relationships to be threatening, even when they're not. And if we don't address the child's past, we will continue to leave the child alone with their fears by avoiding them. And then we'll risk exacerbating their trauma rather than resolving it. So while we get the adopter or the new carer offering the child the love and nurturance they need to help create healthy neurological connections, they need to be mindful that these positive experiences must compete with the child's pre-existing hardwired representations of past relationships. So these are essentially the ghosts of the child's past relationships. And as I say, they're an internalized part of the child. So the child will mistrust healthy caregiving. And I've often heard carers or adopters express exasperation that they're offering the child everything in terms of safety and nurturance, but the child doesn't appear to be benefiting. So a kind of almost classic example is that a child has had a lovely day out with their new family. They've had lots of fun, lots of treats, maybe had a nice cream, they've gone to the beach. That evening, the child comes home, trashes their room, smears feces on the wall, leaving their carers absolutely bewildered as to what's gone on. And it may be that the positive experience with the carer has in fact triggered the child's fears associated with getting close to care figures, because the child's learned that carers harm you or reject you. So the child is essentially protecting themselves from that harm by rejecting the carer first. So when the carer offers the child love and affection, the child might expect harm or rejection and so seek to protect themselves through behaviours that appear challenging, such as withdrawal, self-harm, or acting out. In fact, the child's in that fight, flight, freeze survival mode. And if the caregivers don't understand the child's needs, the risk is the child will overwhelm the caregiver. And this is when placements risk breaking down. And the child's struggles can also, of course, impact upon their wider system, such as their local neighbourhood, how the child presents in school, and ultimately, of course, it can impact to the extent that they're involved in the legal system. So we all need to understand what's going on for the child. So let's look at a more integrated, emotionally containing approach to managing the child's needs. So when the carer offers the child love and affection, and the child goes into survival mode because relationships are a risk, the carer's role is to help the child manage and regulate unbearable feelings. So this is done through reflecting upon the child's experience and through understanding, tolerating, and acknowledging the child's feelings of fear, loss, rejection, and confusion, and trying to help the child make sense of these feelings by helping them understand what's happened to them, including why they're not with their first family, their birth family. And this process is how the child will come to feel understood and safer with their adopter. Over time, through this, what we sometimes call therapeutic parenting process, the child internalizes the healthy care they receive and learns that difficult feelings can be thought about and managed. And this helps the child to understand themselves and their emotions, which allows them to regulate their own feelings, which is what progresses them towards a healthy developmental trajectory. So the green and red representation of the child in the middle here is a child who is internalizing positive relationship experiences while integrating or coming to understand their past experiences of unhealthy relationships. So the red, the unhealthy experiences have not disappeared, but they are better understood and managed because they've been thought about. So in order that the adopter remains able to do this and manage their own stresses and distress, they need the support system around them to help them understand and manage the child. Likewise, the wider system around the child needs trauma-informed support to understand what's going on for the child. So what does the child need to recover from their past and to feel stable with their adopter? They need a healthy relationship to facilitate their developmental recovery. And in terms of recovery, I mean both helping the child to heal from the past and to form trust in relationships that can support their ongoing development. So they need to establish a safe relationship. At the very least, they require a relationship that helps to make them feel safe and stable in a world that has been unsafe and inconsistent. They need help to make sense of their feelings of distress, separation, loss, and rejection by acknowledging the past. It's through being understood they can be helped to understand themselves and then regulate how they feel. They need to form a coherent sense of themselves and a clear sense of their own identity to help address the child's confusion about who they are and where they belong. Adopters must acknowledge that the child's dual identity, that they have two families, even if they're removed at birth. And they need to understand this and be allowed to know their birth family when and if it's safe, and at the very least, know about them when it's not safe. And they need help to make sense of why they need to be looked after with truthful, developmentally appropriate accounts of why they are in care. And they need help to integrate past trauma. By this, I mean help to process and resolve frightening events, such as abuse, that may give them nightmares or intrusive thoughts. So the vulnerabilities of children who have experienced attachment trauma mean they require parenting that is more than good enough. They often require particularly sensitive parenting that helps the child make the connections between their present feelings and their past. Sometimes it's referred to as therapeutic parenting or therapeutic re-parenting. Okay, so we have all this hard work that's being done by the adopter. How does the child seeing their birth relatives impact upon these needs and this therapeutic parenting process? Is contact going to be a help or a hindrance to the adopter? Will contact just be a reminder of the child's traumatic past that's best avoided? Well, as we've seen, past relationships don't just disappear because they're hardwired, internalized in the child's mind. So stopping contact will not stop the child from experiencing reminders of past trauma. Trauma can be triggered by getting close to the carer because in the child's experience, caregivers can be harmful and rejecting. Difficult feelings associated with the past need to be acknowledged and managed and not suppressed through avoidance. So while contact can be emotionally difficult, this does not necessarily mean that it's harmful. We want to prevent the child being left alone with their fears because we as professionals or the child's carers are avoiding them. And there's a helpful quote from a paper by Aya and her colleagues. Aya carried out a review of 49 studies of contact over the past 20 years. And they indicated that well-supported, good quality contact can contribute to children and young people's sense of identity, mitigate issues around attachment, and help children to find a sense of closure and understanding of the reasons for their placement. So as I've said, contact's not just about putting the child and the birth relative in a room together. An alternative way to think about contact is as a potential resource in the child's developmental recovery, provided that it's safe. And what we need to know is, can maintaining a relationship with their birth relative play a helpful role or part in the child's developmental recovery? So as we've seen, the child needs a safe, stable relationship with their adopter. Contact can promote the child's placement stability if the process of seeing their birth relative helps the child to settle or develop their relationship with their adopter. So if the birth relative can support their child's relationship with the adopter, this might help the child to settle with the carer and feel less of a loyalty conflict about investing in a relationship with an adopter other than, or a carer other than their birth relative. Contact might help the child manage their loss and separation if seeing their birth relative helps the child cope with feelings of grief or reassures the child that their birth relative is okay. And contact can potentially serve the purpose of helping the child understand their identity, their sense of who they are, through being able to know who their birth relatives are and ask them about their family of origin, their roots. I had a nice example recently where I was observing a 9-year-old in contact with his mum, and this 9-year-old was left-handed, and he was doing some drawing with his mum, and he noticed that his mum was right-handed. His mum was very limited, but she was able to tell him a little bit about himself, a little about his history. And she was able to say to him, you know, actually, it was your dad that was left-handed. So I'm right-handed, your dad's left-handed. So you're left-handed because of your dad. This boy was so incredibly chuffed to find out that he was like his dad. He'd never known his dad because his dad had died when he was aged 1 due to substance misuse. And he was at an age where he was just trying to understand himself and trying to understand a little bit more about his family of origin. And this was just such it was a lovely moment for the boy to know that he was like his dad on some levels. Children can be helped to make sense of why they're in care if the birth relative is able to appropriately support life story work. For example, by a birth relative helping the child understand the reality of what happened in the past, through acknowledging bad choices as a parent and acknowledging that the child needs to be looked after. And as the child's understanding of their past develops, they need to come to terms with the specific harm that's done to them, such as if they are stuck with frightening memories of events. And that's when contact might play a role in helping the child to integrate their past experiences of abuse or neglect. That's if the birth relative is able to help the child understand traumatic events and that the child wasn't to blame for what went wrong when they were maltreated. So contact needs to have a purpose for it to be meaningful. And these 5 purposes are aligned with the developmental needs of children in care. And contact doesn't need necessarily to serve all these 5 purposes in order for it to be beneficial. Provided contact is safe and appropriately supported, contact can be facilitated to serve one or more of these purposes to ensure that it's meaningful to the child. So when I'm carrying out psychological assessment for the courts, I'm trying to determine what the purpose of the contact will be. What will it mean to the child? And I organise my assessment around whether these 5 purposes can be achieved. So these are essentially the 5 purposes that are integrated into the Safe and Meaningful Contact Guidelines, which I'll touch upon towards the end. Okay, but we do need to recognise that when contact is potentially going to be harmful, contact can be detrimental if it's not safe for the child. And this is likely to be the case when contact exposes the child to perpetrators of particularly severe neglect or abuse, or if it exposes the child to further abuse or neglect through the contact. And interestingly, if it exposes the child to their carers or their adopters' excessive anxiety about contact, because again, this might cause the child that loyalty conflict between their adopters and their birth parents. And contact might also be detrimental if it's poorly facilitated, because if it's not properly managed, contact risks having a negative impact on the child. So for example, if no one's been appropriately prepared for the contact, So in these situations, direct contact would need to be paused because of the risks of potentially re-traumatizing or further traumatizing the child, or of the placement of the child being undermined. So each of the 5 purposes are on a continuum where there are factors about the child, the carer, and the birth relative that make it more or less likely that each purpose can be safely achieved. And what we need to know is where the child, the carer, and the birth relative are on each of these 5 continuums. We can then determine the amount of support required in order to achieve each of the purposes. So sometimes a purpose will actually probably not be achievable because so much support is required to overcome risks. Other times, just a small amount of support, such as changes in the way contact's being managed, can ensure that the contact serves a safe and beneficial purpose for the child. So before we make any decisions about contact, we need to know whether it's being appropriately supported to benefit the child and achieve these purposes. So a crucial part of decision-making is determining whether contact is being appropriately supported to ensure contact is safe and meaningful for the child, or whether it can be safe and meaningful for the child. And often I'll see recommendations based on poorly managed contact with limited consideration of the purpose of contact. However, the evidence shows that well-facilitated contact is associated with positive well-being outcomes for children and young people in both the short and long term. Conversely, poorly managed contact is associated with risks to children and young people's well-being. Support for everyone involved in contact, children, carers, adoptive parents, and birth relatives, is key and depends on the investment of time and resources. To achieve safe and meaningful contact, all parts of the contact system need to be supported. The needs and feelings of the child, the carers, and the birth parents will interact, and they'll vary over time. So each participant has to deal with and is going to be affected by the feelings, thoughts, and behaviours of the others. These relationship dynamics are unique to each case and suggest that looking at the characteristics of one party is insufficient to predict outcomes related to contact. So I want to help you all now reflect upon how contact might be appropriately supported, again, by just doing a poll and asking a few questions. So first one, again, agree or disagree. Chiara, I don't know if the poll can come up. When children become upset and unsettled before and or after contact, it's an indicator that they are re-traumatized by seeing their birth relative, so contact should be paused. Okay, so the majority of you disagree with that statement. I have to stop sharing that. Thanks. Stop sharing that. And I mean, I guess it could be true. The child might be being re-traumatized, but it's not necessarily the case. It could also be false. It could be that contact, it's emotional. It's not going to be a neutral experience. The child may be overwhelmed with grief when seeing their birth relative rather than being re-traumatized. Or they may not have been appropriately prepared for the contact, which can cause them upset, cause them confusion, cause them to become distressed. And the preparation is really key. So this is just a made-up case example, just drawing on my case experience. So there's a 7-year-old boy who became upset after leaving contact with his birth mum. He was then unsettled at his carer's home for the next week with quite a lot of regressed behaviour, including wetting the bed. And based on this, the social work report said that contact was re-traumatizing the boy and that it should be stopped. But the contact that I observed had gone reasonably well with the mother, and the boy were enjoying playing games and dancing together. Yeah, mum had limitations. She was not really in tune with the boy's needs, But to her credit, she'd been able to tolerate hearing her child refer to their carers as mummy and daddy, despite how upsetting that was for her. And my assessment identified that there'd been no preparation for the boy. He was only told that morning that he would see mum for the first time, and it was the first time he was going to see her after 4 months. There'd been a long period where he hadn't seen her. No one had explained what seeing his mum meant or why he was seeing her. So what did this contact mean for this child? Does he think it means he's going to go back to living with his mother? And it makes his world suddenly become very unpredictable. At any minute, I might go and see my birth mum, and, totally out of the blue. So when's that going to happen again? So when he said goodbye to his mum, he was upset, as he'd only just seen her again, and he didn't know when he was going to see her again after that, because no one had ever explained it to him. And also no one had ever spent time helping him understand why he was not able to live with his mother anymore. And his prospective adopters had told him that your mummy's too unwell to look after you, which left him wondering if he would go back to his mother when she was well again. So we can see all the things, that ingredients of confusion and distress that were going into this contact. So obviously in this case, I would disagree that the contact was re-traumatizing the child, even though that can sometimes be presented as a fact. But the child was just essentially upset around the contact and wasn't being re-traumatized. In fact, actually, an alternative possibility is that the way that the contact had been managed was the biggest stressor and the cause of the child's emotional dysregulation that was observed in the boy. Okay, another quick question. Contact arrangements should be determined by the birth parent's ability to safely parent their child during contact time. People agree or disagree? Okay, so we're almost at a sort of 60-40 split with that one. There's the results. So, I suppose generally speaking, I would disagree with that. In adoption cases, we know that the parent does not have parenting capacity. Yet, I must say, most contacts that I observe, the parent is placed in the parenting role, i.e. that they're the child's main carer, even when the parent has been assessed to not have parenting capacity. And if the parent then struggles, for example, with managing boundaries or by bringing too many sweets for the child, I've got experience of these being given as reasons and evidence as to why contact should be stopped. So assessing a parent's capacity for contact is different to assessing parenting capacity in itself. So yes, there will be concerns about parenting capacity if a parent can't keep a child safe in the room, but these concerns can be managed during contact. So, for example, I witnessed a child who was climbing up on a bookshelf. It was clearly precarious during the contact, and there was a risk of the bookshelf falling on the child. And the mum that I was observing did notice this, and she told the child to get down, but she did nothing else. So the child was essentially still at risk. So the supervisor in the room had to step in and make the child safe. And again, this was an incident that was used as part of evidence to stop contact. And yes, the mother's parenting wasn't safe during the contact, but did she need to be in that position of parenting? Did she need to be in charge of the boundaries? She'd been assessed as not having parenting capacity, so she did not need to be left in charge of the child or having the parenting role during the contact for contact to benefit the child. So appropriate management of the contact could have someone else leading the contact time and looking after the child. Ideally, that would be the adopter or a well-known safe adult. Essentially, the birth mother can be a part of an activity and join in without being expected to parent. And then, the child could then still safely know his mother which would serve the purpose of helping him to understand his identity. So we need to be careful that we're not setting up birth parents to fail by having unreasonable expectations of them. And we need to plan contact appropriately around the benefits we're seeking to achieve. Okay, and just another question for you all. Contact must be frequent enough for the child to maintain a nurturing relationship with their birth relative. Okay, so you'll see that result, 75% if you disagree, 25% agree. I don't know the exact split according to professional background, because there's obviously solicitors, social workers in the audience. Be interesting to be able to know that based on your experiences. I suppose essentially I disagree with that. First of all, it's important to note that contact does not need to offer the child a nurturing relationship with their birth parent. Most birth relatives are unable to offer the child a nurturing relationship, by which I mean being an involved, sensitive, supportive presence in their life. So we're not usually seeking to maintain this type of relationship, because and that type of relationship would require frequent contact. The purposes of contact that I've outlined don't necessarily require a high frequency to benefit the child. They can still be meaningful experiences for the child, even if the nature of the relationship isn't nurturing. Conversely, sometimes if the birth relative is able to offer the child something that is nurturing and sensitive, then maybe we would be thinking that of a slightly higher frequency of contact. I mean, that can happen sometimes when children are removed from a very young mother with lots of difficulties that has, moved on a lot in her life and now able to parent her own children. But obviously the child that's been adopted wouldn't be returned to her care, but might be able to offer some sensitivity and nurturing within that context. But the reason I've put this in is because in my experience, contact can sometimes be too frequent for the child's needs, not necessarily post-adoption, maybe sometimes within foster care arrangements. When frequency is too high, it's potentially detrimental to the child's relationship with both their adopter and their birth relative, as the child gets caught in a loyalty conflict between them. So, for example, the child might be wondering where he belongs, or feeling like he would be disloyal to, say, their birth relative by enjoying time with their adopter. And this obviously risks undermining the stability within the placement, and we really need to try and protect stability of the placement at all time, because that's the platform for the child's recovery. And what we're wanting to do is ensure that contacts of good quality, serving purposes that help the child's development, rather than getting too caught up with the quantity. So really, quality of contact over quantity is the key message there. And this is a quote, again, from the Aya paper. Positive experiences do not depend on the frequency of contact, and the reviewed studies consistently emphasize the importance of quality over quantity. Regardless of frequency, contact must be adequately supported, and decisions about the frequency of contact need to be considered in relation to the purpose of contact and account for factors such as children and young people's perspectives, potential risk of harm, and the quality of underlying relationships. Okay, so is there an evidence-based framework we can use to integrate all of this information about the child's needs and how contact can be supported to play a beneficial part in the developmental recovery of the child? Yes, there is. So this is the guidelines that my colleague Anne Woodhouse and me developed. It's the Safe and Meaningful Contact Guidelines, and they essentially evolved out of some of our frustrations that the needs of the child were not always at the centre of recommendations and decisions being made about contact. So the guidelines are essentially a form that you fill in, and it integrates the information that I've covered. It informs the user what they need to know about the child, the carer, and the birth relative to determine whether contact is safe and meaningful for the child. And the user can organize information gathered about the child, the carer, and the birth relative around the developmental needs of the child, outlined in the 5 main purposes of contact. So essentially what you get from the guidelines is they identify how much support is required to safely achieve each of the 5 main purposes and therefore benefit the child's developmental recovery. They also offer guidance about appropriate frequency and supervision of contact arrangements. And once the guidelines are completed, a contact plan is automatically generated, which includes a support plan to achieve the purposes. So there's various settings in which they can be used. And just to say, the guidelines aren't just developed for post-adoption contact. They can be used at any point at which the child's been removed from the child's care. So it could be in the immediate aftermath. We still need to know that when the child is going to see their birth relative, that it's going to be safe and it's going to be beneficial to the child. But the guidelines can be used by practitioners who are making recommendations about contact arrangements to the court, or maybe offering consultations about contact. They can be used by legal decision makers because the guidelines can inform them what information is relevant to decision making in the best interests of the child. And they can be used for supporting or training carers, adopters, and birth relatives as well, to help them understand the potential benefits of contact to their child and their relationship with their child. So I've been delivering training in the SAMPTE guidelines across local authorities and adoption agencies across the UK for the past couple of years, with really positive feedback about how it's helped to improve practice to be orientating decisions around the needs of the child. And if anyone's interested, there's an online training course about the framework on my website. So I want to leave you with a key takeaway point that kind of neatly summarizes the reasons behind why we need to appropriately support contact to achieve safe and meaningful contact organized around the child's developmental needs. Contact that has been facilitated by skilled professionals is associated with improved relationships between children and birth parents, placement stability, a return to parental care, improved emotional well-being, and a better understanding of identity while in care and in adulthood. So provided the contact is safe for the child facilitating it, then it can be meaningful. Okay, that's me. Thank you very much.
Thank you, Dr. Burke. Maybe before we move on to the formal Q&A panel session, we might be able to ask you one question from your presentation. From what we've heard, Dr. Burke, do you agree or disagree with the fact that there may be somewhat of a dichotomy between where we are right now with the law that we've heard earlier on in this presentation and contemporary psychological thinking of post-adoption contact?
I was thinking when there was the presentation earlier about the 8 points from Sheriff Principal Anwar, that there was an overlap actually with the way my presentation and the framework, essentially, that the 5 main purposes kind of could quite complement that way of thinking. So from that point of view, and obviously I'm not fully aware of all the legal system and where everything's at, but I felt that was quite positive to see that.
A question then for you, Dr. Burke, is if the parent is effectively unable, insufficiently self-aware or contemplative to contribute towards the child's understanding of their current circumstances, is it still worthwhile to have that contact continue? Is it enough for the session to simply pose no obvious risks of harm?
Yeah, it's enough to pose no obvious risks of harm as long as they can contain any frustrations they have about the child not being with them, if that's how they feel, as long as they don't go in and undermine. They don't have to be able to contribute to life story work. So if there's those 5 purposes, really the only one that you have to be able to do for safety is placement stability, the first purpose. So, it could be that's purpose 4 on that framework, sort of helping the child understand their life. That might not be achievable, but purpose 3 might be, which is looking at the identity needs of the child. So, the example I gave of the child hearing an anecdote about himself, and, children, like maybe at contact, they will hear their birth relative tell them about when they felt them kicking in their tummy. So these kind of really crucial things. So as long as there's something that the child can get from the contact, if they're just going along and the birth parent is sitting on their mobile phone, not engaging with them, in a way that potentially is replicating neglect anyway, but that would be something that there's no quality to it. There's no furthering of the child for the child in terms of their development. And so it's not necessarily going to be helpful in that context. But yeah, it doesn't have to be that they have life story work from their birth relative.
Thank you. And one more question, which is a really interesting one, is if a child has experience of unsafe or frightening parenting, I presume this is from the birth parent, how does a sanitised, safe and or fun contact experience aid understanding as opposed to providing further confusion or distress or upset to the child?
It's a very good question. I mean, they need to know the reality within which they're seeing their birth parents. So they need to have realistic life story work. It doesn't have to be, full life story work. It can be kind of just a narrative of the child's life. Really want to encourage open communication within adoption, that it is on the table to be talked about all the time, especially children that have memories of birth relatives, to say, that's what your mum would have said, or that's what your mum would have done. Obviously, if they've had really frightening experiences, to go along to a contact that is just set up to be sort of fun, there's a lot unacknowledged there, and it might undermine it. That potentially could undermine the placement, because the child might not feel like the carers that they're with can keep them safe from that, and they go along and they have to put on their false self, if you like, that they might have adapted to learn to do, to be around their birth relative. And so therefore, we'd be really carefully looking at, is this a safe form of contact? Is there a risk that that would undermine the placement? So yeah, that's why I'm talking about how important preparation is. If there's this unacknowledged elephant in the room that actually, we're playing snakes and ladders together, but you used to batter me, then it's not helpful for the child.
Another point which has been raised, and it'd be useful to have your insight, Dr. Burke, is about the use of life storybooks for children to enable them to have an understanding of their journey through their care to adoption and beyond. What benefit do you see of life story books, and is there some important factors that need to be considered when considering the content of those books?
Yes, they need to be well written, very carefully thought about. I've come across really terrible life story books, sadly, that even potentially alienate the child against their birth relative. I mean, they do need to know the truth, and maybe that is necessary if they've really been severely harmed by their birth relative. But I had one in a particular case where the child was being told that the birth relative was preventing them being adopted, and they understood what adoption was and they wanted to be adopted. But of course, that wasn't the truth. The birth relative was actually agreeing to the adoption, but they were fighting for contact, and that was delaying the process. So yes, life story books really important, but they have to be well written. They also have to be revisited all the time. So so sometimes I'll say, does the child understand their life history? Well, we read them the life story book when they arrived with us in our care, so yes, they do. And of course, they've had that story once, and that's been put away. And there's research to say that we often think that children understand much more than they do about their life. So that's why I talk about open communication. We need to be getting that well-written life story book out every single day, almost, as part of that. Let's talk about you and let's talk about your life, understand your identity. If it's too challenging because it's about them, you can sometimes use third-party sort of books. So for example, this is a book about a little cuddly bear that got taken away from his birth parents, and he's now living with these other people. So the context in which the child is helped to understand this information can be made a little bit more palatable for the child as well. So yeah, but yeah, main message, make them good life story books.
Thank you, Dr. Burke.
Thanks.
Thank you to everyone for your attention so far, and for what has been an insightful series of presentations relating to permanence and adoption. Now, as we open the floor to our Q&A session, we would invite all of you once again to take the opportunity to actively participate. This is the perfect moment to ask questions, seek clarification, or share your own experiences relating to permanence and adoption, including the issue of post-adoption contact. If you haven't already done so, I would encourage you to all send us a question using the Q&A function on Zoom. So let's discuss some of the questions from the audience, and our panel here consists of the people who have presented so far and colleagues from Brodies. So if I could start with a question that's been posed to us. So from what we've heard, when there's no contact taking place between biological parents and the child post-adoption, how do you manage contact between the child and siblings who've potentially been raised in another household? I wonder, maybe Dr. Burke, if I could come to you first about the psychological aspects of the sibling contact versus the issue of post-adoption birth contact with birth parents.
Yeah, so ideally sibling contact would happen, and we should try to make it happen as much as we possibly can. But of course, I mean, there are certain circumstances if there's a child at risk, say, because, I had one case where an older brother was sexually abusing the younger child, and it wasn't going to be safe to have the contact. There's also sometimes circumstances where if one of the siblings is living with the birth family, we can then assess that child, the older sibling, to determine whether or not they are safe, using all the same purposes that I've talked through. Are they going to come along and support the child in their placement, or are they going to undermine the placement in some way or another? But, also you might get the adopter, two different adopters. One of the children of the sibling pair, for example, might understand full well why they're being adopted and why their history. The other child might not have ever been told by their adopters. And again, I've come across these situations. And so having contact together really might be quite difficult for the adopter who really struggles to talk to their child about their life history. So it's thinking about the impact that's going to be had on the children of all these things.
Isabella, from a legal perspective, are the same considerations in place for sibling contact, particularly in terms of recent case law and your experience, as the considerations for the court when looking at contact between a birth parent and a child?
Yes, they are. The test is welfare. What is in the best interest of the child, having regard to that child's welfare. The only difference in adoption would be that the court would require to consider that in the context of the child's life rather than just throughout childhood. So while the evidence might be different, the legal hurdle is exactly the same. There have been, as you know, a lot of discussion recently, all the way to the Supreme Court, about the input of siblings in the lives of each other. While they are not automatically relevant people before the children's hearing, it's recognised that they have a significant part to play in each other's lives, and the disappearance of them may be necessary, but the welfare of each particular child may be interdependent on the other, and therefore contact should, if it meets the test, be considered.
There's, of course, Isabella, been recent consideration by the courts of Article 8 rights in relation to sibling contact, both in the context of children's hearings and in the context of adoption. So I would say that it's probably something that's been considered more recently than it has ever been, looking at the issue of sibling contact, not just contact between a birth parent and a child. The wider family and familial relationships are being considered as part of the process and the welfare test.
Well, absolutely. And I think the last case I did before I went into Crown Office, it was all about sibling contact. There was no prospect of post-permanence or the parents having contact, but there were orders made in that case for particular sibling contact that was highly organised and regulated and exclusive.
This is one maybe for Donna McKay. Donna, what options are available if an order is made in an adoption process for contact and post-adoption contact transpires to be inconsistent or breaks down completely? What can you do? And I think maybe an extension of that question perhaps then is, if there is an order for post-adoption contact and the birth parents want to enforce that if it's not happening, what can be done?
Right, two slightly different things. So I'll deal with your first query first, Gary, which is, what can you do if the contact turns out to no longer be in the child's best interests? And the answer is that it's similar to what would happen if contact in any case turned out in the longer term not to be in a child's best interests. The court can be asked to look at the situation again. The test remains what is in the child's best interest, and that can change and develop as children develop and they get older, and they perhaps form their own views about certain things, where at the point of the adoption they may have been deemed to be too young or sufficiently not sufficiently mature to have formed a view. So the contact can always be looked at, provided there has been a material change in circumstance. So an adoptive parent cannot just go back to the court and say, well, I just don't fancy facilitating this anymore. It's a bit of a nuisance having to do this. It needs to be shown that there's been a change of circumstances and that the contact is no longer in the child's best interests and ought to be reviewed. The second part of that was about what to do if you are the birth parent and the contact order, which was granted by the court, is no longer being obtempered. And this is actually something that is currently under review with regards to the Children's Scotland Act 2020, which is certain provisions of this are not in force yet, but they're going to reviewing the whole system regarding failure to obtemper court orders. And essentially, the birth parents could be held to be in contempt if they're failing to uphold the terms of an order which was granted by the court. So again, a sheriff would require to investigate this and look at this and make a determination of whether the birth parents were in contempt. And if they were found to be in contempt, then there are penalties that the court can impose on the adoptive parents. They could be fined. In severe cases, imprisonment is an option that's available to the sheriff. So these things are taken hugely seriously.
I wonder then, just looking at another aspect of contact, and this is maybe one more for, again, Dr. Burke, when parents are unreliable in attending regular contact, at what point would you say this becomes too damaging to continue? It's essentially the question seems to be, what is the cutoff point?
Yeah, well, so we need to be reviewing contact regularly, and essentially, if the child is experiencing their parents not come, they are experiencing further neglect by their parent, essentially, and therefore it might, in the child's experience, obviously depending on the age of the child, it might be helpful for them. Sometimes we try and protect children by not telling them that the contact's coming up, so that when they actually arrive at so that they don't go along to contact when the birth relative isn't there. But in some ways, if they're old enough, it might be helpful for them to see once that actually this is part of the problem and why you're in care, because your birth mum or dad or whoever finds it really difficult to come along to think about you and look after you and come and see you. So I would also emphasize that we need to be supporting the birth relative to be there in the context of adoption. Again, the parent doesn't need to be able to demonstrate parenting. It's of benefit to the child if we can support the parent to be there, because then the child gets all the identity needs met, etc., of knowing who their birth relative is. So if they struggle to attend of their own, we then need to put in lots of resources. So, we might pick them up to bring them along. We might give them reminders. We might give them money to help them get to the contact. But if they're still failing in the context of that support, then I think we need to be thinking, well, this isn't in the child's interest because it's not reliable enough and we need it to be reliable enough. So, when I'm assessing if parents really don't turn up very regularly, first of all, I'm checking how are they being supported. And then secondly, I'm sort of likely to say, well, if they're not attending regularly, then they're not demonstrating being able to keep the child safe within the context of contact.
Thank you, Dr. Burke. Donna, this should be hopefully one that you can answer fairly quickly. You spoke in your presentation about parents lodging a form of response in the adoption process when a petition is lodged. What happens if the parents don't lodge a form of response but turn up to the preliminary hearing, for example? Can the court still consider their opposition to the adoption?
Yes, indeed, Gary. In my experience, the sheriff absolutely will consider anything that they wish to say at that hearing. To fail to do that would likely simply result in any decision being made by the court being subject to appeal. So the experience I've had is that they will absolutely be given an opportunity to speak at the hearing and make their views and their position in relation to the adoption known. One
for Fiona then. Fiona, your insight, and maybe just in your view, as we all know, one of the audience members has suggested that adoption is often referred to as draconian. What does the future look like, in your view, for adoption and permanence when we look at this sort of emerging case law?
Yeah, thanks, Gary. It's interesting, and it was interesting hearing you ask the question to Isabella earlier around what are the benefits of a POAA versus adoption and direct petition. I think looking at it from a local authority perspective, often what's happening and what is emerging through the processes is there is this real, obviously there's a real focus on what's in the best interest of these children, what's in the best interest for their future, how do we secure a safe and nurturing environment for the child's future and give them that security of a permanent placement somewhere. But more and more, I think, and I've noticed it over the last few years, more and more we're taking into consideration around having that post-permanence contact with birth parents be slightly different to what it probably was, 5, 6, 7 years ago, where you're looking at perhaps indirect letterbox contact. I think that now we are much more, and certainly Chris had touched on this in his presentation, we're much more holistic kind of interview and what's in the best interest of the child, and perhaps cutting that contact is not the right answer. So in terms of adoption going forward, I don't think, whilst I appreciate the question is that, adoption can be considered draconian, I think in the best interest of a lot of these children that are looked after children, they have been looked after from a very, very young age in their life, and they do require the security of a forever family and a placement. So I don't know that I see there's going to be a particularly huge change in a trend in relation to perhaps adoptive placements, but I do think there will be a change in a trend in relation to what that contact may look like with birth parents in the future.
This is a question more for the legal members of the panel, and I'll open the floor to Fiona, Donna and to Isabella. A really interesting question then, and I see this crop up more and more recently. Making an order for life or throughout childhood is so permanent when the children develop, and parents may also evolve somewhat. What does the panel think about looked after child reviews making changes to contact measures that form part of a adoption order, if that was to be embodied into a contact order? So, for example, in the adoption order, it may say that there's direct contact twice a year to be reviewed at LAC reviews by the local authority. One, maybe it's a two-part question. Is that the appropriate way of reviewing contact? And two, can the court still review in those circumstances?
I suppose in terms of looked after child reviews, I think something that I often think when I'm working on permanence order cases that are being contested is that whilst we're there from a legal perspective to say this is what the legal tests are and here's how you meet those tests and here's how you achieve or exceed those tests, I think what's really important and kind of what Chris had touched on as well before is that really the social workers and local authorities are the professionals in relation to having worked with these children over such a significant period of time. They undergo an awful lot of training in relation to what contact should look like with birth parents and how to work with them and how to support them in the right way. And I think there's a part of that we have to be guided as legal professionals to say this is what the legal tests are from what those social work professionals are saying in relation to how that should look, and therefore on that basis I can understand why they sit with the looked after child review, within that structure in order to make those determinations.
this is a question for Dr. Burke.
Sorry, Gary, could I just come back on that? I wasn't very clear how post-adoption order there was still a LAC review engaged, because of course an adoption order would extinguish all care orders. So how having an adoption order that had contact that was subject to review by the LAC would that not be inconsistent with the order?
Indeed, but in permanence cases that may be the case. But in adoption orders, there can often still be a request that any variation to the contact be considered by the local authority. So I wondered if just your thoughts on that as a general process. Is there maybe a bit of a power struggle between whether that's a matter to be determined by the court or to be determined by the local authority for variation to future post-adoption contact?
Yeah, so I would have thought that variation of post-adoption contact should not be a decision of anyone in the local authority, because one would like to hope that post-adoption, the engagement of the local authority was de minimis, and certainly becoming so would be the objective. And I would have thought that what you would be looking for post-adoption, and Dr. Burke may have a view about this, is to look at it in a much more a process that's distant from the turmoil that was engaged in achieving the adoption, and to look at it as a welfare decision at the time that you're seeking the review, having regard to all the facts and circumstances extant at that time, and not have the potential overlay that might still exist from any contentious litigation.
Yeah, I would just agree that contact's not static. It's fluid. Circumstances will change for everyone, and it needs to be reviewed regularly. And if it can be done within the adoption, if the adopters are sensitive to the child and are able to say to the child, would you like to meet with your birth family now? Would you like to see them, etc.? That could be a part of the process of change that they could instigate, maybe without any external supports, if they can locate the birth relatives. How they would get support to do that. I think local authorities do work on trying to support that post-adoption. But yeah, I don't know the ins and outs of all the support mechanisms for that.
Essentially, it can't be a unilateral process dictated by the social work department or the local authority. Any post-adoption variation has to be a much more involved process, as Dr. Burke has said, with the adoptive parents, with the child, taking account of current circumstances, and not dictated by anyone.
If it did say, and this is maybe a difficult question, Isabella, to answer, but if there was a feature of an adoption order in terms of post-adoption contact that stated that any post-adoption contact would be reviewed by the local authority, would the court still have, in terms of the statutory powers, to be able to review that contact?
Well, the order for contact would have to be reviewed, not within the adoption process, but would be a Section 11 application, I think. I cannot imagine a circumstance where a court would decline jurisdiction to regulate the matter of a welfare of a child. The court has an overarching parens patriae jurisdiction in welfare matters, and would not automatically defer to an arrangement regulated by the local authority unless it was satisfied, having considered it. I would have thought that arrangement met the welfare test for the child.
There's some really great engagement in terms of the Q&A box. We're getting a lot of questions, and I think we'll probably have time for one more. This is a really interesting point that I would open out to the whole panel. There's quite a lot to this question, but this relates to the issue of post-adoption contact and post-permanence contact. And the involvement of the children's hearing system, and the potential idea of the horse before the cart. So at children's hearings, at the hearing when they're considering advice to court, for example, on recommending permanence and termination of direct contact at that point, it then makes it difficult at a later stage for birth parents to seek reinstatement of contact in the adoption process. Do the panel have any views on this? I wonder, Isabella, if you might be able to help with that one.
I think it's very much a contentious issue, and you're right, Gary, to categorise it as the cart before the horse. Courts like maintaining the status quo up to a point, certainly in permanence orders, to a point of their decision being made, and they are, in my professional experience, sometimes aggravated by the children's panel having usurped their ability to do that by snookering the arrangements before it gets to consider them. The way to review that is, of course, to review the children's panel decision. But I think that local authorities have to be careful about how they submit their reports to the panel in respect of seeking recommendations. And when they're doing that they're doing it in good faith, having regard to the welfare of the child only, and not having regard to making their permanence order application easier, because there is then the suggestion of them acting in bad faith and putting their social workers, when they're in the witness box, in a very difficult position. I think it's a very difficult decision-making process to separate out in time terms. But I think that panels who terminate contact before a permanence order decision has been made have to do so for pretty compelling reasons and be quite robust about the basis upon which they've made that decision, in order that it doesn't become the subject of judicial criticism.
Maybe one final question then for Dr. Burke, and it seems to me to be an issue that recurs quite a bit throughout these cases, is where a child is placed with concurrent foster carers and prospective adopters, and the child is encouraged to call the prospective adopter or adopters mum and dad, and the tensions that it might cause. It's also the issues of post-adoption, the sort of, from a psychological perspective, the names to be attributed to individuals, like, for example, tummy mummy, mum. From a psychological perspective, do you have views on this and the impact that this might have on the adoption process and even the legal process?
I think children can differentiate if they have two mums or two dads, and they can they differentiate. You might have two grandmothers, both called Granny, but they know which one's which. They might refer to one as Granny Jane, Granny Linda, or whatever, different names. But so children often within care will, whether it's even short-term foster care, they will perhaps just copy the other children in the house and call the carer mummy or daddy or whatever. And so there are psychological benefits to the child of doing that, but in terms of their sense of safety and fitting in with peers and all sorts of reasons. So I don't have a problem with it being part of the child's adaptation to their circumstances, really, at any stage, as long as it's alongside clear life story work, as long as we're not deceiving the child and saying, so as you say, you might be saying, well, that's your tummy mummy, or that's, the mummy who you grew inside, etc. As long as you're kind of helping the child to know who that person actually is, then the rest of it, I think, is okay for the child. And I don't think that would undermine the ongoing process of the child being adopted.
Thank you, Dr. Burke. There's been a lot of engagement through the Q&A function, and unfortunately we don't have time to answer all of the questions that have been posed, but I want to thank everyone for their very active engagement in the Q&A session. So just as a final thought then, I want to thank you all for joining today's webinar on adoption. We hope that the discussions that we've had today have been informative and insightful. Your participation, particularly in the Q&A section, has been invaluable in making this event a success. As a follow-up, we'll be sending out some information to all attendees shortly after the conclusion of today's webinar, which includes a recording of the presentation and the further information relating to the presentations. Once again, thank you again for your invaluable contributions, and we look forward to staying connected in the future.